The letters was sitting under a Tupperware lid on my kitchen counter. My mother had been in my house while I was at work. She still had a key from when I had my knee surgery 4 years ago, and she'd left it there like it was a grocery receipt. Like it was nothing. It was from Hargrove and Blaine, a wealth management firm in Scottsdale. I'd never heard of them. Dear Ms. Patricia Wren, pursuant to the power of attorney filed on behalf of your parents, Robert and Diane Calloway, all discretionary distributions from the Calloway Family Trust have been suspended pending review. I read it 3 times standing at my counter in my work clothes, still holding my laptop bag. Suspended. My trust. The one my grandmother Edna had set up in 1987 with money from the sale of her farm in Kingman, Arizona. The one that had been quietly growing since I was 22 years old. $520,000. Suspended. I set the letter down. I walked to the sink. I ran cold water over my wrists, something I've done since I was a kid when I needed to think straight. Then I picked up the letter again. Power of attorney. My parents did not have my power of attorney. I had never signed one. I've worked in financial compliance for 23 years. Right now, I'm a senior fraud examiner at a regional credit union in Tempe. Desert Ridge Federal, off McClintock Drive. Before that, I spent 11 years at a forensic accounting firm downtown. My entire career has been looking at documents and asking, is this real? Who signed this? When? Why? I know what a forged POA looks like. I've testified in 2 civil cases involving forged POAs. I've sat across from people who swore on their lives that a signature was genuine, and I've shown them, line by line, pressure variation, ink inconsistency, that it wasn't. The letter said the POA had been filed 6 weeks ago. 6 weeks. March 14th. On March 14th, I was in Sacramento for a compliance conference. I have the hotel receipt. I have the Uber receipts. I have a photo on my phone of me and my colleague Dana standing in front of the Capitol building at 2:14 in the afternoon. I was not in Arizona on March 14th. I did not sign anything on March 14th. Here is what my life looked like before that letter arrived. I live alone in a 3-bedroom house in Chandler that I bought in 2011 for $187,000. My daughter Kelsey is 26 and lives in Portland. We talk every Sunday. I drive a 2019 Camry with 74,000 miles on it. I have a rescue greyhound named Archie who sleeps on the couch and pretends not to hear me when I tell him to get down. I take the same route to work every morning. Chandler Boulevard to the 101, exit at McClintock, coffee from the Dutch Bros on Warner. I'm at my desk by 7:45. I review transaction reports, flag anomalies, write documentation. I talk to compliance officers at other institutions. I sit through a lot of meetings about wire transfer protocols. My life is not dramatic. That's by design. I spent my 30s in a marriage that was nothing but drama, and when it ended, I chose quiet. I chose routine. I chose Archie and Sunday calls with Kelsey and the same coffee order every morning. My parents live 20 minutes away in Mesa, in the house I grew up in on Dobson Road. I see them most holidays. We're not close, exactly, but we're not estranged either. My mother sends me articles about supplements. My father forwards me chain emails about the election. Normal, ordinary, fine. The first thing that felt off wasn't the letter. It was 3 weeks before the letter, when my mother called me on a Tuesday afternoon. She almost never calls on weekdays, and asked me, very casually, whether I'd ever thought about simplifying my finances. I remember I was eating a salad at my desk and I said, "What do you mean, simplifying?" She said, "You know, consolidating, making things easier to manage." I said my finances were pretty simple already. She said, "Well, you know, your grandmother's trust is a complicated structure. It might be worth having someone look at it." I said I had someone look at it every year. My accountant, Lou Ferrara, handled it. She said, someone new might see things differently. I thought she was just making conversation. My mother makes a lot of conversation that doesn't go anywhere. I finished my salad and forgot about it. I'm not going to forget about it now. Because the question I can't stop turning over, the one that kept me up until 2 a.m. that first night, is not just how they did it, it's who helped them. Before I tell you what happened next, I'm Jennifer, and you're watching Diana's Secret Stories. If family drama, hidden secrets, and true-to-life stories are your thing, hit subscribe and join our growing community. Now, here's what happened. I didn't call my parents that night. I almost did. I had my phone in my hand, my mother's name on the screen, but I put it down. 23 years of compliance work teaches you one thing above everything else. You do not alert the subject before you have your documentation in order. I made tea instead. Earl Grey, from a box I've had since Christmas. I sat at the kitchen table with the letter, a legal pad, and my laptop. And I started writing down everything I knew. The trust was structured as a discretionary trust, which meant distributions weren't automatic. My grandmother had set it up so that I could request distributions for specific purposes: a home purchase, medical expenses, education, and the trustee would review and approve. The original trustee was a man named Gerald Hutchins, an estate attorney in Kingman who'd handled my grandmother's affairs. Gerald died in 2018. After his death, the trust had been transferred to a successor trustee, me. I was the trustee of my own trust, which is not unusual for a beneficiary of my age, which meant that for someone to freeze distributions, they would need to remove me as trustee first. The POA wouldn't have been enough on its own. Even if my signature had been forged on a power of attorney document, that document would have needed to go somewhere, to a court, to a financial institution, to someone with authority, and that someone would have had to act on it. Hargrove and Blaine hadn't created this problem. They were just the firm holding the assets. Someone had filed paperwork with the Maricopa County Superior Court. I knew this the way I know most things in my field, by understanding what the process has to be before I see the documents. The process required a petition. A petition required filing. Filing created a record. I wrote down, pull court records. First thing tomorrow, I called Lou Ferrara at 7:45 the next morning from the Dutch Bros parking lot, before I even went in to get my coffee. Lou is 61, been doing taxes and trust work in the Phoenix area since 1989. He sounds like a man who has never once been surprised by anything. When I read him the letter, he was quiet for a long moment. "Patricia," he said, "who have you told about this? You're the first call." "Good. Don't call your parents yet." That told me something. Lou had been doing my family's taxes since my divorce. He knew my parents only as names on a document, had never met them. But his first instinct was the same as mine: don't tip them off. "Can they actually do this?" I asked. "Depends on what they filed and who accepted it," he said. "A POA alone can't remove a trustee. They'd need to file a petition for trustee removal and get a judge to sign off. Or," he paused, "or they found someone at Hargrove and Blaine who didn't ask enough questions. Or both," I thought. It could be both. I went to the Maricopa County Courthouse on my lunch break. The clerk's office on West Jefferson Street. I'd been there twice before for work-related matters, so I knew where to park, knew which window to go to, knew to bring my ID and the trust documentation I'd pulled from my home filing cabinet that morning. There was a filing, dated March 12th, 2 days before the date on the POA itself. A petition to modify trustee authority, filed by Robert James Calloway and Diane Marie Calloway, listing a law firm I'd never heard of as their representation. Sutter and Vane, LLC, with an address in Gilbert. The judge who'd signed the temporary order was the Honorable Mark Delvecchio. The order was temporary, which meant there would be a hearing date. I found it at the bottom of the last page. June 19th, 5 weeks away, 5 weeks to undo whatever my parents had built, or watch them walk away with control of $500,000 my grandmother had left to me. I stood at the clerk's window and kept my face very still. The woman behind the glass asked if I needed copies. Yes, I said. Everything you have. What I couldn't figure out, what I kept circling back to, was Sutter and Vane. I'd never heard of them. In a mid-sized legal community like the Phoenix metro area, I have a passing familiarity with most firms that handle estate and trust work. You develop it over years of sitting across from opposing counsel in fraud cases. Sutter and Vane didn't ring any bells. I looked them up that afternoon from my office computer, which I did not feel guilty about, because this was now, unambiguously, a matter requiring professional judgment. The firm was 18 months old. 2 attorneys listed, Christopher Sutter and Andrea Vane. No prior firm histories listed on the website. A stock photo of a handshake on the homepage. A contact form and a Phoenix area phone number. Brand new firm, no track record, no history I could find. My parents had been married for 54 years. My father was a retired electrician who had never, in my memory, hired an attorney for anything. My mother was a former school secretary who clipped coupons and kept every receipt in a shoebox under the bed. These were not people who shopped around for obscure law firms. Someone had pointed them to Sutter and Vane. That was the question I fell asleep thinking about. Not what my parents had done. Not even why. Though that question was sitting there, waiting, the question was, who was standing behind them? The answer came from a direction I wasn't looking. My daughter Kelsey called on Thursday, not Sunday, Thursday, which was unusual enough that I answered on the first ring. She said she was just checking in. She asked if I'd talked to my parents lately. I said not recently. She said, "Okay," in a tone that wasn't quite okay. "Kelsey, I'm not supposed to say anything." "Who told you not to say anything?" Silence. Then, "Grandma called me 2 weeks ago. She said you were having some kind of mental health crisis and that they were worried about you making decisions about your money." I was sitting at my desk. I put my pen down very carefully. She said, "What?" She said you'd been acting erratic and that she and Grandpa were just trying to protect you. She asked me not to bring it up because it would upset you. Kelsey's voice was careful, measured. She'd always been the steady one, even as a kid. "Mom, are you having a mental health crisis?" "No. That's what I thought. How long have you been sitting on this?" 2 weeks, she said. "I almost called you 5 times. But Grandma said," I know what Grandma said. I pulled up a blank document on my computer. "I need you to tell me exactly what she told you, word for word, as close as you can remember." "Can you do that?" She could. She did. I typed while she talked. The story my mother had told Kelsey was specific and detailed. That I had been making erratic financial decisions. That I had talked about withdrawing large sums from the trust to give to a man I'd been dating. That I had missed 3 family dinners in a row and seemed not like myself. I have not been in a relationship in 4 years. I have not missed a family dinner in my recent memory. I haven't requested a distribution from the trust in 2 years, and that one was for a new HVAC system. But the story was detailed enough, specific enough, that someone hearing it without context might believe it. This was not my mother improvising. My mother cannot improvise. She is a woman who needs a written list to go to the grocery store. This story had been given to her. Lou Ferrara had a contact at the Arizona State Bar. a woman named Rosario who handled complaints and could pull registration histories. He called me back on Friday afternoon. Christopher Sutter had been licensed in Arizona for 19 months. Before that, he'd been licensed in Nevada, where his license had been suspended for 22 months following a complaint related to document preparation in a probate matter. Suspended. Not disbarred. Suspended. Which meant he could reapply, relocate, and start over somewhere new. Andrea Vane had been licensed in Arizona for 11 months. No prior state bar history under that name, which didn't mean no prior history. It meant no prior history under that name. Lou read me this information in the same even tone he uses to tell me about depreciation schedules. "Patricia," he said when he was finished, "this firm has the signature of a chop shop." A chop shop. In estate law, that's the informal term for a firm that mass produces legal documents for clients who want results without scrutiny. They don't ask too many questions about the underlying facts. They file what they're paid to file. "Someone hired them to file the petition," I said. "Not just my parents." "That's my read," Lou said. "So we have a forged POA, a shady law firm, and someone feeding my parents a story about me being incompetent." I was writing as I talked. "Lou, who benefits if control of this trust shifts away from me?" He didn't answer right away. "Pull the trust document tonight," he said. "Look at the remainder beneficiary clause." I already knew what was in that clause. I'd read the trust documents a dozen times over the years. But I pulled them out that evening and read it again, and when I got to the remainder clause, the provision that described what happened to the trust assets if I died or was removed as beneficiary, I sat very still for a long moment. The remainder beneficiary was my parents, jointly, and after them their estate, which meant if I was removed as the primary beneficiary, the trust didn't go to Kelsey. It didn't go to charity. It went to Robert and Diane Calloway, all $520,000. I called Lou back. "When was the last time you read this clause?" he asked. "Years ago," I said. "I always assumed it would go to Kelsey. Common assumption, worth checking." He paused. "Patricia, I want you to call an attorney tomorrow. Not to react yet. Just to have someone in your corner who can walk into that June 19th hearing." I already had someone in mind. Her name was Margaret Osey, and she ran a one-woman practice out of a 2-room office above a dry cleaner on Camelback Road. I'd met her 12 years ago when she'd served as opposing counsel in a trust fraud case I'd consulted on for the firm I worked at then. She'd won. I'd respected her ever since. Margaret was 63, originally from Accra, had been practicing Arizona estate and trust law for 30 years. She kept a small wooden elephant on her desk, and she did not waste words. I brought everything: the Hargrove and Blaine letter, the court filing, the copies from the clerk's office, my notes from the Lou call, the typed transcript of what Kelsey had told me, my Sacramento hotel receipt, the Uber receipts, the photo with the timestamp. She read without speaking for 20 minutes. I sat in the client chair and watched pigeons on the window ledge outside. "Forged signature on the POA," she said finally. It wasn't a question. I wasn't in Arizona that day. "We'll need a handwriting expert. I have one I use." She turned a page. "This Sutter, the Nevada suspension. I want the complaint documents. Lou's contact at the state bar can get them." "Good." She set the papers down and looked at me over her reading glasses. "Patricia, I want to tell you something, and I want you to hear it carefully. What your parents have done is a serious thing. If the POA is forged and we can prove it, that is not a civil matter. That is a crime." "I know. Are you prepared for that?" I thought about my mother calling Kelsey. The specific, detailed lie. The story about a man I wasn't dating, money I wasn't moving, dinners I hadn't missed. Someone had built that story and handed it to her. I'm prepared to find out who built this, I said. All of it, where it started. Margaret nodded slowly. Then let's start at Sutter and Vane. She filed a motion the following Monday, a motion to stay the temporary order pending a full evidentiary hearing, on the grounds that the POA on which the petition relied was potentially fraudulent. She attached my Sacramento documentation. She attached the summary of Sutter's Nevada history. The motion landed on Judge Del Vecchio's desk on a Tuesday. By Thursday, we had a response. Not from Sutter and Vane, from a different attorney entirely, a man named Harrison Price, of Price and Associates in Scottsdale. Old firm, established, the kind of address and letterhead that cost money. Harrison Price had been practicing for 40 years. He had a photograph on his firm's website that looked like it had been taken at a country club. Harrison Price was now representing Robert and Diane Calloway. Sutter and Vane had disappeared from the case entirely. Margaret called me the same afternoon she received the substitution filing. I could hear something in her voice that wasn't quite alarm, but was in the same zip code. Someone upgraded their legal team, she said. Who paid for it? That is exactly the right question. Harrison Price did not come cheap. I knew his name in the Phoenix legal community. You knew his name. He handled high-stakes estate disputes, business litigation, the kind of cases where the retainers started at $50,000. My parents lived on Social Security and my father's electrician's union pension. Together, their monthly income was about $4,100. Their house had a small mortgage. They drove a 2017 Buick that my mother called the good car. They could not afford Harrison Price, so someone was paying for Harrison Price's. And that someone had decided, somewhere between Monday and Thursday, that a chop shop attorney in Gilbert was no longer sufficient. The pressure was coming from somewhere I still couldn't see, and now it was wearing a very expensive suit. Margaret and I met again on the following Saturday morning. She made coffee on a 2-burner hot plate on her filing cabinet. It was strong and slightly burnt, and I drank it without comment. She had pulled Price's recent case history through public records. Arizona court filings were public, if you knew where to look. In the previous 3 years, Harrison Price had appeared in 7 trust or estate disputes in Maricopa County. 5 of those cases involved the same financial advisor on the opposing side. His name was David Reyes. He ran a boutique wealth management practice called Pinnacle Advisory Group, with offices in North Scottsdale. He also, I learned from Margaret's research, had a referral arrangement with Hargrove and Blaine, the firm that had sent me the letter in the first place. I sat with that for a moment. Hargrove and Blaine freezes my trust. Harrison Price appears to defend the action that froze it, and in 5 recent cases, Price had been on the opposite side from a financial advisor named David Reyes, which meant in those 5 cases, Price had been working for Reyes's interests, not against them. They're a team, I said. Circumstantially, Margaret said carefully. She was a cautious woman. She did not make claims she couldn't support. But you see it. I see a pattern worth documenting. She poured more coffee. Patricia, I need you to go back further. I need to know how your parents were first connected to any of these people. Sutter and Vane, Reyes, Hargrove, and Blaine. One of them was the entry point. Which one did your parents meet first? I didn't know. I needed to find out. And there was only one way to do that. I was going to have to talk to my parents. I called my father. Not my mother, my father. 68 years old, spent 30 years as a licensed electrician, voted in every election since 1978. Called me Patty, even though I'd asked him not to since I was 19. He was a man of very specific habits and very specific loyalties, and he did not, in my experience, volunteer information under pressure, but he also could not maintain a complex story. He'd never been able to. When I was 14 and crashed the family car into the neighbor's fence post, it was my father who accidentally told my grandmother what had happened at Easter dinner 3 weeks later. I asked him if he wanted to have lunch. "Just the two of us," I said. "The Denny's on Dobson, the one we used to go to after church when I was in elementary school." He hesitated. Then he said yes. He was already there when I arrived, sitting in a corner booth, wearing his ASU baseball cap, turning his coffee cup in circles. He looked older than he had at Christmas. Something around his eyes. I sat down. I ordered eggs I didn't want. We talked about the weather and a plumbing issue he'd had in the garage. Then I put the Hargrove and Blaine letter on the table between us. He looked at it for a long time without touching it. "Dad," I said. "Who is David Reyes?" His jaw tightened, just slightly, just enough. "He's a financial advisor," he said. "He came to a seminar at the Elks Lodge 8 months ago." He said. He stopped. "What did he say?" My father looked out the window at the parking lot. A woman was loading groceries into a minivan. He watched her for a moment. He said your trust was structured badly. He said you were at risk of losing most of it to taxes if you died without changing the structure. He said he'd helped a lot of families in similar situations. He turned back to me. He said if you weren't going to do anything about it, someone needed to protect what Mama Edna built. Mama Edna. My grandmother's name, used only by family. How did he know her name? I asked. My father blinked. He must have asked. I must have mentioned her. "Dad, how long had you known this man before you mentioned Mama Edna's name to him?" He looked at his coffee cup. "One evening," he said quietly. "It was one evening at the lodge. There it was. Not malice, exactly. Not the scheme I'd been building in my head, the sophisticated, coordinated fraud. My parents were not criminal masterminds. My father was a retired electrician who went to Elks Lodge meetings and trusted a man who used the right name at the right moment. Someone had done their research. Someone had known enough about my family to walk into an Elks Lodge in Mesa, Arizona, and use the name Mama Edna in a sentence. That was not a coincidence. That was preparation. Which meant this had started long before March 14th. Long before Sutter and Vane and Harrison Presace and the letter under my Tupperware lid. Someone had been watching my family for months. And my parents had used their love for their mother, their worry about their daughter, their ordinary human desire to fix what they thought was broken, as instruments to take what wasn't theirs. I paid for breakfast. My father tried to apologize. I told him I needed him to trust me now the way he'd trusted David Reyes, and I needed him to tell Margaret everything he remembered. He said, "Okay." He looked like a man setting down something very heavy. Margaret filed a formal fraud complaint with the Arizona Department of Financial Institutions the following week. She also contacted the FBI's Financial Crimes Division in Phoenix, not because she expected fast action, but because she wanted a federal timestamp on the record. I went back to work and did what I do. I pulled every public record I could find on David Reyes and Pinnacle Advisory Group. Business filings, licensing records, FINRA registration, any civil actions in Arizona courts. My employer's database access didn't extend to personal investigations, so I worked on my own time at my kitchen table, with Archie's chin on my knee. Pinnacle Advisory Group had been registered in Arizona for 4 years. Before Arizona, Reyes had operated a similar entity in Colorado under the name Summit Wealth Partners, dissolved 18 months before Pinnacle was formed. I found one civil judgment against Summit Wealth Partners in Denver County, a client family who had alleged unauthorized transfer of trust assets. The case had been settled, confidentially. The pattern was the same: different state, different name, different clients. Same structure. He moved every few years. He dissolved, reformed, relocated. He targeted elderly clients with adult children who had inherited trusts. He cultivated access through community events, through senior centers, through Elks lodges and church groups. He built relationships over months before he asked for anything, and then he filed paperwork, or he had paperwork filed. I compiled everything into a single document, 47 pages, organized by date, with source citations for every item. Cross-referenced with the Maricopa County filings, the Sutter and Vane registration, the Hargrove and Blaine connection to Price. I sent it to Margaret on a Wednesday night at 11:15. She called me Thursday morning at 7. "This is very good," she said, which from Margaret was the equivalent of anyone else saying this is extraordinary. Is it enough? It's enough to go into that June 19th hearing and make a compelling case that the POA is forged, the petition is fraudulent, and the parties involved have a documented pattern of similar conduct. She paused. Whether it's enough to take David Reyes down personally, that depends on what the FBI decides to do with the federal complaint. What about the hearing? The hearing I can win, she said. I'm going to ask for sanctions against Price for filing a petition he had reason to know was based on fraudulent documents. That'll sting Ugg and my parents? Silence. That's your decision, Patricia, not mine. I drove to Mesa on a Sunday. My mother was in the front yard deadheading roses when I pulled up. She looked at my car and went very still. I got out. I walked up the driveway. She set her garden shears down on the porch railing. "Patricia, I'm not here to fight," I said. "I'm here because I need to understand something, and I think you're the only one who can tell me." She clasped her hands together in front of her, the posture she'd always taken when she was frightened and trying not to show it. "When David Reyes told you I was making erratic decisions," I said, "did you believe him, or did you want to?" She didn't answer right away. "He showed us paperwork," she said finally. "He showed us account statements. He said you'd been making inquiries about liquidating the trust. That paperwork was fabricated." "I know that now, Mom." I kept my voice level. "Why didn't you call me? Before any of this? Why didn't you just call me and say, 'Patty, we're worried about this. Can you explain it?'" She looked at the roses. The yard was meticulous, as it always was. 30 years of her tending this yard. "He said if we called you, you'd just find ways to hide it better," she said quietly. "He said that's what people in financial trouble do." It was elegant in a terrible way, preemptively disabling the one safeguard that might have stopped everything. "The attorney," I said. "Harrison Price. Who paid for him?" My mother's face shifted. Something like relief, actually, like she'd been waiting for someone to ask. "David said he knew someone who could help," she said. "He said it wouldn't cost us anything because it was in everyone's best interest to protect the trust." So Reyes had paid for Price, or arranged the payment, which meant there was a financial connection between them that could be documented. That was the piece I needed. The June 19th hearing was on a Thursday. Margaret and I arrived at the Maricopa County Superior Court on West Jefferson at 8:30 in the morning. She was carrying a document binder that was 1.5 inches thick. I was carrying a copy. Harrison Price was already in the hallway. Gray suit, silver tie, the particular posture of a man who had stood in many courtroom hallways and found them comfortable. He glanced at us. He didn't speak. His clients, my parents, were on a bench against the wall. My mother was wearing her church clothes. My father was turning his ASU cap in his hands, the way he'd turned his coffee cup at Denny's. I sat in the gallery and waited. The hearing room was smaller than I expected. Judge Delvecchio was a trim man in his early 60s, with reading glasses on a lanyard. He opened by noting that he had received and reviewed the motion to stay filed by my counsel, as well as the response from Price and Associates. Then he looked up from his papers. "Counsel," he said to Margaret, "your motion raises some serious evidentiary concerns. I'd like to hear from you first." Margaret stood. She did not use notes. She laid it out methodically. The forged POA, the Sacramento documentation, the handwriting analysis she'd commissioned from a certified examiner, who had found 6 specific inconsistencies between the signature on the POA and my verified signature samples. She presented the Sutter and Vane registration, the Nevada suspension, the Colorado civil judgment against Summit Wealth Partners, the FINRA records, the pattern of relocation. She then presented a bank record. It had taken Lou Ferrara's contact at a forensic accounting firm 3 days to trace it. A payment of $35,000 from a Shell LLC registered in Delaware, Cornerstone Holdings LLC, to Harrison Price's office trust account, made 9 days before Price entered the case. Cornerstone Holdings LLC had been registered by David Reyes. The courtroom was very quiet. Price stood when it was his turn. He was measured. He said the payment was for unrelated legal services. He said the POA had been properly executed, and any concerns about the signature were a matter for experts to dispute. He said my parents had legitimate concerns about trust mismanagement. Judge Delvecchio took off his reading glasses. "Mr. Price," he said, "are you aware of the complaint filed with the Arizona Department of Financial Institutions regarding your client David Reyes?" A pause, small but visible. "I'm aware of an inquiry," Price said. "And are you aware that Mr. Reyes is referenced in a FE financial crimes complaint that was filed 4 weeks ago?" Another pause, longer. "I was not aware of the FBI matter," Price said. He said it the way people say things when they are choosing each word like they're stepping across ice. The judge vacated the temporary order from the bench. Right there, that morning, he restored my trustee status, lifted the freeze on distributions, and issued a referral for a bar investigation into Sutter, specifically regarding the circumstances of the POA preparation. He also issued an order requiring Price to provide documentation of the Cornerstone Holdings payment within 14 days. When it was over, Margaret and I walked out into the hallway. My parents were still on the bench. My father stood up when he saw me. "Patty," he said. "Dad." He looked like he was trying to find something to say that would reach across everything. "He seemed like someone who knew what he was doing," my father said finally. "He knew things about our family. He said he'd helped people like us." "I know, Dad, Ed. I should have called you." "Yes." My mother was quiet. She was looking at the floor. I watched her for a moment, the church clothes, the hands clasped, the stillness she always retreated into when she didn't know what else to do. "We didn't think you'd listen," she said without looking up. "We've never thought you listened to us." It landed differently than an accusation. It landed like something true that had been sitting in a drawer for years. I didn't have an answer for that. Not right then, in a courthouse hallway. "Come to Lou's office next week," I said finally. "Both of you. I want to show you the full trust document, what it actually says, what Grandma actually intended. Will you come?" My father said yes immediately. My mother took longer. Then she nodded. David Reyes was indicted by a federal grand jury 11 months after the hearing. 4 counts of wire fraud, 2 counts of elder financial abuse under the Arizona revised statutes, 1 count of conspiracy to commit fraud. The indictment listed 9 victims across Arizona and Colorado over 6 years. My family's case was count 3. I gave a victim impact statement. Not at sentencing, the case hadn't gotten to sentencing yet, last I heard. I gave it to the federal prosecutor, a young woman named Anitha Krishnamurti, who took 14 pages of notes and asked good questions. The 47-page document I'd compiled became part of the government's exhibit file. Christopher Sutter's law license was revoked by the Arizona State Bar 8 months after the hearing. Andrea Vane's license was suspended pending investigation. Harrison Price was publicly censured and fined. He did not lose his license, which Margaret said was infuriating but not surprising. He issued a statement saying he had been deceived about the nature of the Cornerstone Holdings payment. Maybe he had been. I found I cared less about Price than about the people who were easier to deceive. My parents came to Lou Ferrara's office on a Tuesday in July. My father wore a collared shirt. My mother brought a lemon cake she'd made from a recipe she'd had since the 70s, the kind with the box of lemon pudding mixed into the batter. She set it on Lou's conference table without saying anything. Lau walked them through the trust documents. All of it. The original language from 1987, the successor trustee provisions, the remainder beneficiary clause, what it meant, what it didn't mean. My father asked questions. My mother wrote things down in a small notebook. At the end, my father looked at me. "Your grandmother knew what she was doing," he said. "She did. We didn't trust that." He shook his head. "We thought someone needed to fix it. I know." There was no clean resolution to that part of it. They were my parents, and they had been used. And they had also let themselves be used because they didn't trust me, had maybe never quite trusted me. The daughter who moved away and built a career they didn't fully understand. And I'd stop asking them for advice sometime in her 30s. David Reyes had found that gap and walked straight into it. That part we didn't resolve in a conference room in Tempe. We're still working on it. Some of it we may not ever resolve. Kelsey came to visit in October. She slept in the second bedroom, and we made breakfast together 3 mornings in a row and watched a documentary series about ocean life that was completely unrelated to anything that had happened that year. On her last morning, she sat at the kitchen table while I scrambled eggs and said, "Are you going to change the trust document? Update the remainder beneficiary clause?" "Already done," I said. Margaret handled it. Kelsey Marie Wren, primary remainder beneficiary. She was quiet for a moment. "Mom," she said, "you should have told me sooner. I know, I could have helped. I know that too." I put the eggs on the table. Archie positioned himself hopefully at Kelsey's elbow. Outside the kitchen window, it was the particular flat October light of the Phoenix Basin, not quite fall, not quite anything yet. The neighbor 2 houses down was mowing his lawn at 7:30 in the morning, same as he always did. I poured coffee. We ate breakfast. Kelsey slipped Archie a piece of toast when she thought I wasn't looking. I didn't say anything. Some things don't need correcting.